Viewers, welcome back to the show. This episode we're going to do a WorkCover update, but before we get on to one of the cases we want to do, we've had two Facebook comments, one from an Angelo and a Rachel. Both comment about the fact that Angelo says he's still at work after being badly injured, and Rachel says her father's continued to work for 10 years, notwithstanding the fact that he's got a very nasty back injury. John, what's your take on people continuing to work when they've got nasty injuries?
Look, they're, not only medically and physically, they're not doing themselves any favours, Tony, but for any WorkCover claims, again, they're literally damaging their own claim.
Well, more importantly, they've both said that they're getting worse. So obviously they're doing a lot of medical harm to themselves, aren't they, Nardine?
Of course, Tony, of course. It's really important to be able to listen to the general practitioner's advice, but really know your limits with respect to what type of capacity that you do have to be able to perform these duties at work.
What's 93CD, Nardine?
93CD, Tony, is a top-up provision that is available to workers. So provided that you're able to demonstrate that you can work more than 15 hours a week and earn more than $150, WorkCover will be able to top up the difference as your previous employer. So it's available to workers that might be instead of working a 38-hour week, can work maybe a 15, 20, 25-hour week and still be able to get that top-up difference.
And you're only losing 20% on the hours you're not working, which is not a big amount, is it, John?
Exactly, Tony. And this type of provision, it's a safety net, isn't it, Tony?
It is.
And it helps the worker that he can't work full-time anymore because of his, let's say, back injuries or any other type of work injuries, and he's working to his maximum, and he gets, that little bit extra top-up from WorkCover. And this also helps, Tony, doesn't it, the 40% economic loss test?
I was going to get to that, but before I get to that, the 93CD process, you basically get a certificate from your treating doctor.
That's right.
To say you can work 15, 20 or 25 hours. You do a letter to the insurer, is that correct?
That's right.
They'll say yes or no, and if they're unhappy with the assessment, they'll send you off to a medical panel. Is that correct?
Exactly,
John?
yes.
So it's not a difficult process, is it?
No.
And now, John, what's a 40% test?
Well, for our serious injury applications, the gateway for common law damages, if you want to pursue a claim for economic loss, a claim for future lost wages, you need to show that you've lost more than 40% of your earning capacity. Now,
so if you're earning $1,000 a week, you've got to lose $400 a week to be able to pursue loss of income.
As a mathematical equation, exactly.
Okay.
The problem is when you've got a worker that's working more hours and not losing that 40%, well, technically, they're not able to pursue that claim, Tony.
Okay. In Rachel's case, her father's continued to work with this really, really bad back for 10 years. What's his prospects of getting a claim for loss of income over the line, Nardine?
Well, it looks very minimal, unfortunately, Tony. It does mean that we'll have to assess the tax returns quite carefully, but if it means that he's been working full-time...
10 years.
Full-time, 10-year basis, it's unfortunately might be limited to, yeah, that's right, a pain and suffering claim, if any.
And John, what's the difference in value?
Oh, the difference in value could be $300,000-$400,000, Tony.
So
it's depending on the age of the worker, as we all know. Pain and suffering damages for workers in Victoria are capped at $540,000, but economic loss claims are capped at $1.4 million, Tony. So it's a big difference. Now, at the same time, and we've got workers that fall in the trap of working in basically sheltered workshops, sheltered environments that are offered by the employer. Now, again, the courts will take that into account that if you're working, you're working. And you're not losing the 40% test. You're not reaching the 40% test. The problem is, as we both know, Tony, after the case is finished, the worker usually gets sacked.
Your position's very precarious, to say the least, isn't it, Nardine?
That's
exactly.
Right.
Look, I think because workers are scared to lose their jobs and they're worried about getting alternative jobs in the future, a lot of them continue to do the same hours and same duties. Isn't this an appropriate time for them to get on the phone to someone that's an expert or specialist in WorkCover?
That's right.
To give you some general advice on how to protect yourself. Not only protect yourself from the law, but also how to protect your own body. Is that a fair comment?
Well, we've only got one body, we've only got one life. That's the ideal scenario, Tony.
And Nardine, you want to get to retirement with some functioning of your body, don't you?
That's true, and it's nice to be always to have a healthy mind, healthy body to be able to continue on with the life that we can live.
If you want to get the benefits of the fruits of your labour, you don't want to get to retirement and you're a cripple, do you?
Exactly.
But having said that, viewers, the best thing to do is, a lot of lawyers in this area practice on a no-win, no-fee, so make an appointment, get on the phone, make an appointment, go and see a lawyer, and I'll give you the basics on what to do to protect yourself and to preserve your rights.
Exactly, Tony. All workers, the legislation is there. You're able to access it. Seek legal advice.
In fact, the 93 CD provision was introduced by Mr. Kennett, which was probably one of the few good things he did under the workers' comp legislation.
Apart from abolishing common law, Tony, yes, that was probably the one shining element.
I think it was a great provision, Nardine, because it kept people at work. And it also needs cooperative and sympathetic employees, I think.
It does.
Is that correct?
It does, 100%.
All right. Who's going to give me the facts of Pasqualotto and Pasqualotto? Now, the surnames are the same because it's a case of a son suing his parents. Nardine, do you want to give us the facts?
Well, it seems that this young boy at the time, or young guy, works on a tobacco farm with his parents. Initially sustained injury back in 1997 to his lower back and underwent fusion at the time by the care of a particular surgeon. And the evidence at the time of the trial was that surgery was
been successful.
Been successful, that's right, Tony. Eventually goes back to work on his parents' farm, harvesting quite long hours, 12-hour days in particular periods. And in a particular date in March of 2005, he says to his dad, look, my back is sore, I'm not feeling well, I think I should stop. And his father says, no, continue, we need to keep on going.
Finish your run.
Finish the run, that's right. And to which the son, after an hour and a half or so, the evidence was led that he couldn't continue and he felt the greater onset of lower back pain.
John, one additional fact that it's pretty critical is when Mr. Pasqualotto Jr. got injured in 1997 in a car accident, his mother attended with him on quite a few occasions to see Mr. Brasnor, the surgeon. What's the relevance of that?
Well, Tony, the worker has seen the surgeon, and the surgeon, Mr. Brasnor, has advised him, in particular on one occasion with the mother present, that you can't go back to work on the farm.
John, we're going to have to go to a sponsors break. We'll keep the viewers in suspense and we'll get back to it. Viewers, stay tuned. We'll be back shortly.